Good afternoon, everyone. My name is Teilen Celentano. I'm an employment lawyer with Samfiru, Tumarkin, LLP, and welcome to today's iteration of the Live Employment Law Q&A. As always, if you guys have any questions, feel free to ask them on the comments or wherever you can. We're streaming live today on Facebook, LinkedIn, X, Twitter, YouTube. If you can't comment, you can go to our website at employmentlawyer.ca, email us at help@employmentlawyer.ca, or give us a call at 1-855-821-5900. So I'd like to start today by talking about the Dell layoffs. Layoffs in the tech industry continue en masse. Most recently, Dell announced that they were laying off quite a few employees in Canada. And whenever there are mass layoffs, irrespective of the size of the company, there are enhanced obligation on employers in order to take care of their employees by way of severance packages. But those notwithstanding, those packages are always in accordance with the minimums of the Employment Standards Act. And almost always those employees are entitled to additional compensation. So even if you're ever part of a mass layoff, it's really important that you don't just take the offer, which may seem fair on its face. Don't just take it. It's always important to reach out to an employment lawyer at Samfiru, Tumarkin, LLP. And one of us will be able to take a look at the package and really advise you whether or not the package is fair or whether or not it is needing of improvement. And if it's needing of improvement, then one of our lawyers will be able to help you out. I would also like to talk about another blog that I wrote and was actually posted on our website earlier this week. The lead-in topic was Pete Carroll and Bill Belichick, two NFL coaches who lost their jobs, but both of their firings have a lot of parallels, deal with a lot of issues that we see frequently. Now, as some of you may know, NFL coaches are unionized, so their rights are different, and obviously they didn't work in Ontario. But in the case of both coaches, they were terminated for failing to meet owner expectations, right? Both teams, the Seahawks and the Patriots, missed the playoffs, and their coaches were let go after a couple of years of underperforming. So that kind of lends itself to the question of, can I get fired for cause if I fail to meet expectations? And the short answer of it is that you technically can, but it's exceedingly difficult for that to happen in Ontario. In Ontario, in order for a company to terminate someone for cause, they need to show that they were given a huge runway to try and improve, that the expectations of ownership were reasonable, and that the employee was given every opportunity to succeed. Generally, there needs to be multiple warning letters, a performance improvement plan. If the employee doesn't meet the objectives in the performance improvement plan, then they need to revise it and give the employee another chance. It's exceedingly difficult for an employer to justify a just cause termination on the grounds of performance. And that's because our courts in Ontario have deemed that termination for just cause is a capital punishment of employment law. So just like in the real world in the criminal law courts, capital punishment, we don't even have it here, but in the US, it's the most extreme punishment reserved for only the most heinous of crimes. Similarly, the capital punishment of employment law, termination for just cause, is reserved for the most heinous instances of workplace misconduct. And in the case of those two coaches, finishing 7-9, a losing record, but still not even being dead last, it's not just cause. The other issue, one of the other things that is a parallel from those situations to the ones I frequently see in my capacity as an employment lawyer with Samfiru, Tumarkin, LLP, is that these coaches were terminated prior to the end of a fixed term contract. Now, both coaches were under contract for not only all of the season that just finished in the NFL, but also Pete Carroll was under contract for the season starting in 2024 and Bill Belichick for 2025. So they both were terminated early. In Ontario, when an employee is on a fixed term contract, meaning you will start on this date and it will end on this date, barring a enforceable termination clause, which is very rare, The employee, when terminated early, is actually entitled to be paid the balance of the fixed term contract. So let's say, for example, an employee on Ontario were to sign a contract on January 1st of this year of 2024, and it was set to expire on December 31st, 2024. But after 4 months, the company decides it's just not working out. So they let them go at the end of April, let's say May 1st. Well, what that employee is entitled to, again, barring a very well written specific contractual terms, would actually be those last 8 months of the contract. They'd be entitled to their full pay from May 1st all the way to December 31st. It is different than a traditional severance suit, but there is a lot of stuff there, and there is it's always worth calling us whenever someone is let go, reaching out to us at employmentlawyer.ca. And if you are on a fixed term contract, there are times where you may be entitled to more money than if you'd been an indefinite term employee. And the last parallel is that both coaches were given the opportunity to step down. Pete Carroll specifically was offered a position in upper management of the Seahawks in Seattle. Now, oftentimes in pro sports, those coaches are approached and said, "We're letting you go. Would you like to be fired, or would you like to step down?" Essentially, the coaches are given a choice between getting fired or quitting. In Ontario, if an employee is given that choice, right, your boss comes up to you and says, "Hey, things just aren't working out. We're going to have to let you go today." And if you want to save face in the office, we can say that you've resigned. Being given that choice to resign or to be fired is not a real choice, right? So what our courts would say is, before making that decision, I would like to say, talk to a lawyer, reach out to us. But if you're put on the spot and you do pick the option of resigning, that doesn't mean you aren't entitled to a severance package. Our courts understand that a resignation needs to be a completely voluntary act undertaken by the employee, meaning they were the ones who did it. There was no external forces from the company that influenced their decision. They decided to resign, and therefore, they're resigning. But if you're given that choice, it's not truly voluntary. You're trying to save face and you're trying to protect your reputation. So in a case like that, that employee was given the choice and chose to resign would likely still be entitled to a severance package, which, if you've seen any of our shows before, can be as much as 24 months, depending on the conditions and in terms of your contract. And then the last thing that is a good parallel to what we do is that when assessing a severance package, our courts look at a number of factors. Age and length of service are generally the two given the most consideration, but other factors are also weighed, right? Things like your immigration status, if you have to work in a specific field, or even English and French being your non-first language, right? Our courts recognize that it is at times, it is at times more difficult for people who don't speak the language of the land to find a job. But another thing our courts look at is the availability of similar employment, right? So in the case of 2 NFL coaches, right, there are 32 NFL head coaching jobs in the world, right? So there are really only 31 comparable jobs to the jobs that Pete Carroll and Bill Belichick lost. So in that case, it is extremely, there's extremely limited available comparable employment. It's even further reduced when you consider the fact that there aren't 31 other jobs that get hired every year. A lot of coaches stay on for multiple years, and there are only a handful of vacancies every year, and there's a ton of people competing for them. So given the low availability of similar employment, if those coaches, Pete Carroll and Bill Belichick specifically, were entitled to an Ontario severance package, which again they are, it would likely be enhanced because there is less similar employment available. In applying that to an Ontario context, if you live in a very remote town in Northern Ontario where there aren't very many jobs, there's less available employment, you're likely entitled to a larger severance package. Or if you work in a very niche area, an area where there aren't a lot of businesses operating in and there aren't a lot of jobs available in it. I remember in law school, there was a case where someone sold radioactive isotopes, right? There was one company in the whole world that did it. There were 2 salesmen in the whole world that sold radioactive isotopes. And that person was entitled to an enhanced severance package larger than they would otherwise be entitled to, because there was so little available similar employment. And it's such a niche, unique field that his experience in that role wasn't very transferable to other jobs. So jumping now into the questions, we've already had a few come in. So first, David on Facebook asks, I was working as a subcontractor for a company for over 10 years, collecting the same check from them for that time, but there was no contract signed between us. Then I was fired with no cause. Do I have rights to severance? Absolutely, you do. So if you're a subcontractor, the question always becomes whether or not you're an independent contractor, a dependent contractor, or an employee. So those are the 3 big classifications. Now, just because the initial agreement was for you to be an independent contractor isn't actually determinative of the relationship. Our courts will look at what they call a non-exhaustive list of factors in order to try and ascertain whether you were in fact a contractor or an employee. Excuse me. If you were an employee, the courts will look at things like control is the biggest one. Do you have a company uniform? Is there a dress code? Do they tell you when to work? Do they tell you what to work on? That kind of stuff. The second thing they'll look at is ownership of tools. Did you work with their tools, their laptops, their cell phones, their this, their that, or did you have your own? Another thing is a chance of profit or a risk of loss. In your case, David, you received the same paycheck by the sounds of things for 10 years, right? For over 10 years. That would lead me to say that there was no chance of profit or risk of loss. And when our courts interpret, chance of profit, they're not just saying, a commission on a sale. That's not viewed as a chance of profit. What they're really alluding to are things more like, you get paid for the job, thinking of a plumber who is getting paid to replace the toilet. He's getting paid to replace the toilet. If it takes him 1 hour, if it takes him 10 hours, if the contract was to replace the toilet, he gets paid the same amount of money. In your case, if you were getting the same paycheck every year, there wasn't a chance of profit, because if you finished a certain task sooner, you couldn't pick up another one. You couldn't pick up another job and, either with the same company or with another one to earn more money. Similarly, if one job took you far longer than you expected, you weren't out any money. And then the last one, the courts will look at is integration into the business, right? Or integration organization test. How integral was your role to the business itself, right? Sticking with the example of a plumber, if you are a plumbing company, right? Somebody who sells plumbing services, the plumbers on your staff are likely employees, because what they do is at the core to what your organization does. Whereas if you're a law firm, right, you may need to hire a plumber to come fix a toilet in the office. It's totally normal. But while you do need functioning toilets in every office space, it's not core to the business a law firm does. So that would lend to say the contractor working for the plumber working for a plumbing company, well, likely an employee, whereas the plumber working for a law firm, likely a contractor. Other things they look at in that test: do you have a company email? Do you hold yourself out to be a representative of the company you work for, or do you hold yourself out to be, working for yourself and representing that company on a contract basis? And then lastly, time is always a big thing. If you're somewhere for 10 years, well, technically possible for you to be a contractor, it's more likely that you're an employee. Now, even if you were a contractor, there's a second group, a second element of the test is whether or not you were independent or a dependent contractor. If you received all of or the majority of your income from one company over the course of 10 years, it is likely that even if you were a contractor, you were a dependent contractor. And in cases of dependent contractors, while they're not entitled to everything an employee is, you may also be entitled to, you would still be entitled to severance, right? So our courts have said dependent contractors who wholly depend on one company for their living, are still entitled to severance as if they were an employee. So yes, David, if you work for one company for 10 years collecting the same check, it is likely that you are entitled to a severance package. So I'd suggest reach out to one of our lawyers right away. And in addition to severance, there may be other things you're entitled to. If you've been paid as a contractor for 10 years, then you likely didn't receive things like vacation pay or public holiday pay. Both of those are additional pay on top of an hourly rate or a base salary that people who get paid on an hourly or weekly basis need to receive. So under the Ontario Employment Standards Act, the bare minimum vacation pay an employee is entitled to is 2 weeks or 4% per year of service for their first 5 years. And once they hit 5 years of service, it increases to 3 weeks or 6%. In addition to that, there's public holiday pay. Public holiday pay is worth on average about 3 to 7% of your total earnings, right? So if you earn $100,000, your public holiday pay on an annual basis is worth $3,700. So if you were an employee who worked there for longer than 10 years, paid as a contractor, and a court determined that, even though you were paid as and, employed under the guise of being a contractor and you were in fact an employee, not only would you be entitled to a severance package, but you would also be entitled to potentially back vacation pay and public holiday pay going back all the way throughout your employment. For the year 2023, as an example, it would likely be 6% vacation pay, 3.7% public holiday pay. So if you made $100,000 a year, in addition to severance, you'd be entitled to an extra $9,700 just in back vacation holiday pay for last year. So David, in a situation like yours, it's extremely important you reach out to a lawyer, reach out to us so you can speak with one of our employment lawyers. Easiest way is employmentlawyer.ca or at 1-855-821-5900. Next question is from Jack. I'm a superintendent at an apartment building. A new management company wants me to sign a contract for the role I've already been in. The existing verbal agreement with the previous company was that I could revert to being a tenant should I decide I didn't want to continue in the role. No contract was ever signed, nor is there any evidence of that agreement. If I refuse to sign the contract, can I be evicted? And or can they force me to sign a new lease? So Jack, it's a very tricky situation. Building superintendents are always in very precarious situations, obviously, because of the situation they're in. I think the first thing you need to do in a case like this is protect yourself. And the best way to do that is to hire a lawyer. And reaching out to us, an employmentlawyer.ca is going to be, likely should be your first step. But just because something isn't in writing, if you do have a verbal agreement, it's still a contract, right? So the term and condition of your employment for however long you had been there with the old management company was that you could revert to being a tenant should you decide you no longer wish to be the superintendent. That is still a term and condition of your employment, right? And there's nothing, at law that the employer, the new management company can do to take that away. Now, the difficult part with that, as I'm sure you can imagine, is proving it, right? We would need to prove that was a term of your contract. And if there's no contract, nothing was ever in writing, then you're in a difficult spot. There are a bunch of things you could do in order to try and confirm it. The first thing would be, reaching out to the new management company and articulating this was your old agreement. This was the old agreement, and I want to make sure that it continues. Or even reaching out to your old supervisor, old bosses who may have been aware of that agreement, who can attest to it, right? Things like an email or a text message, again, getting it in writing so there's some level of paper trail is definitely something you're going to want to do. In terms of signing a new contract, it's going to depend. It's going to depend on a lot of things. If you've watched if you've ever watched Suits, which growing up I loved, you'll know that every contract needs three things. It needs offer, acceptance, and consideration, right? An offer of a contract is just, here, please sign this. It's very straightforward. And acceptance is just signing it. But that third element, that's consideration, right? And what is consideration? It is something you're given in exchange for signing that contract, right? Our courts have said continued employment isn't valid consideration, right? So if you have been working in a job and your boss comes up to you and says, hey, I need you to sign this new contract. Your rate of pay isn't changing. Nothing else is changing. I need you to sign this new contract. Well, our courts have said that you are, as the employee, giving up something in exchange for nothing. And therefore, that contract had no consideration. And it is therefore unenforceable. It's not worth the paper it's printed on. Now, employers can get around that. They can give you, $1,000 signing bonus for signing the new contract, as an example, and that would be considered consideration. So I don't know what the what the situation exactly is, Jack, with this new contract they're trying to get you to sign. But if an employer is ever saying during your employment, hey, please come and sign this new contract, the general rule, it's best to have a lawyer look it over, because there are a lot of potential pitfalls, right? A lot of potential pitfalls to you signing this contract and not, if you signing this contract in which you may be giving away. If they try and evict you, if they try and, terminate you for not signing it, then you would, of course, have to, if it's housing related, generally we don't deal with it. It's more of a landlord-tenant issue than it is an employment issue. But I think before doing anything, Jack, in your case, it would be best to give us a call so we can take a look at everything, and so we can confirm, really get a tailored analysis of what your situation is, because there's a lot of things at play. And when you're obviously dealing with your home, the potential of getting evicted, there's, the possibility of maybe being homeless. If you decide not to sign this contract, there are a lot of things that you need to take into consideration. You really need tailored legal advice in a situation like that. So reach out to us, Jack. One of our lawyers will be able to help you out. Joseph on Facebook asks, I'm on sick leave due to complications with my operation. My time for healing was delayed, which in turn had to change my date of return. My employer said they modified the work, which my doctor stated would be. My employer said they have modified work, which my doctor stated would be after an assessment. The employer said they have made their decision. I must return to work on modified duties on my next scheduled shift. What do I do? Joseph, if your doctor is saying you can't return to work and you've provided the company with the doctor's notes, medical notes confirming it, then you don't have to return to work. An employer can't impose can't impose that you circumvent your doctor's orders in order to serve them. That's not the way it works. No judge would ever support that. That is completely asinine behavior. So if your doctor is saying, Joseph had surgery, had his knee replaced, had his arm reset, whatever it is, and his healing process got delayed because of an infection, because of this, because of that, and he therefore, if he was supposed to return on February 7th, but now can't return until March 1st, the company has to accommodate that. Under both the Employment Standards Act and the Ontario Human Rights Code, or if you're federally regulated, the Canada Labour Code and the Canadian Human Rights Act, the employer has an obligation to accommodate you. They have an obligation to make adjustments so that your medical disability can be accommodated in the workplace. So no, you don't have to show up on your next regular shift, and the employer is completely out of line for having tried to do that. Now, if when you don't show up for that next shift, the employer tries to discipline you, either by way of suspension or by way of termination for cause, they are completely in the wrong. And not only would you be entitled to a severance package, which, as I've said today, can be as much as 24 months, you'd also be entitled to additional damages for breaches of your rights under the Ontario Human Rights Code and the Employment Standards Act. So I think obviously reach out to us, Joseph, so one of our lawyers can help walk you through the minefield that is returning to work after a medical leave. But even more so than that, papering everything is extremely important, right? So telling your employer, my doctor said, in very clear and unambiguous words, my doctor said I need to be off until this date. I will not be coming into work until my doctor has cleared it, at which time I will need the accommodated duties. Please confirm that you'll govern yourself accordingly. Something along those lines would be, a very good email, text message to send to your boss. And again, putting things in writing so that if you're ever let go, there's a paper trail. And if the employer tries to give you a hard time about it, know that they're in the wrong, and them just doing so may even be enough to establish a constructive dismissal and allow you to go after a severance package, on your own. So without even actually being terminated. So Joseph, your employer is absolutely in the wrong. What do you do? I think you reach out to one of our lawyers first, and in the meantime, try to paper everything. If your employer, employers are allowed to ask for, reasonable updates, during your recovery process, right? They're allowed to say, Joseph, when are you going to be able to come to work? They're allowed to say, Joseph, when you come back to work, what will you need in order for us to accommodate you? And they might even say, Joseph, if you're going to be off for the next 3 months, we'd like it, at check-in every 6 to 8 weeks. All those things are reasonable, and provided they're not harassing you for it, you are obligated to comply and cooperate and to, actively participate in the accommodation process. But, the employer isn't a doctor. They're not your doctor. They don't get to decide whether or not you're ready to come back to work on modified duties. That's a decision for you, and that's a decision for your doctor. Kaylee on YouTube has asked, I asked my employer for a pay increase given extra workload due to new acquisitions. They deny my request as I'm a manager and said my current pay accounts for this, and I'm a manager. Is this true? So, Kaylee, under the Employment Standards Act, under the common law, there is no standalone right to a pay increase, right? There is no there's no law that says, when your employee is given new duties that they need to be paid more. Obviously, the exception being if you get paid minimum wage. If you get paid minimum wage in the law, the Employment Standards Act revises the minimum wage, well, then you need to get paid more. You're entitled to that raise. But that aside, there was no standalone right to a raise, right? Similarly, you've kind of hit the nail on the head. Under the Employment Standards Act, managers are not entitled to overtime, right? So the general rule for overtime is if you're working more than 44 hours per week, every minute you work over that, you're entitled to time and a half, right? So if you get paid $20 an hour, as an example, well, for the first 44 hours that week, you get 44 hours, you get paid $20 an hour. And then if you work 6 more hours, well, then for those last 6 hours, you get time and a half. So 20 times 1.5 is 30, you get $30 an hour. Now, in a situation like this, where you've taken on an increased workload, I don't think it would be crazy to say that, it is unfair. You are doing more work, you should be getting more pay. If you've already taken on these new duties and new obligations, then, there isn't much you can do. But asking that employer for a raise is fine if they say no. But now the next time that they, go to try and ask you to take on more work or do more things, you are within your rights to say, look, I'm already, working above capacity and I can't take anything else on. I can't work any more hours. The difficult part with that is obviously the working relationship, right? This is the workplace you're in every day, and it does get difficult. But I think, to answer your question bluntly, Kaylee, there is no standalone right to a pay raise at law, right? Even if you're taking on new work. Now, you don't have to take on the new work if you're asked. You don't have to show that initiative. You don't have to show that drive, that ambition. But it can obviously make things in a workplace sometimes a little more difficult. If anybody else has a question for today, I'm happy to answer it. But otherwise, thank you for joining me today. Please join us again. Our next show is actually Disability Law Q&A on Tuesday, February 6th with one of my colleagues out of BC, Martin Wilmies. And, well, it doesn't look like we're having any more questions coming in, so that'll be it for today. Thank you all for joining. My name is Teilen Celentano, an associate and employment lawyer with Samfiru, Tumarkin, LLP. And if you need to reach out to us or have any more questions, our website is employmentlawyer.ca, and our phone number is 1-855-821-5900. Thanks, and I hope you all have a great day. Bye-bye.